good afternoon, and good evening, depending on your time zone. We are here once again, back to discuss important issues. There have been many problems in the southeastern part of Nigeria, of which the governors are the custodians of the law, and also the security of the states are under the governors of each state of southeastern Nigeria, just like others. However, it is unfortunate that Igbos no longer have political personalities, but today they have servants of other considered political juggernauts who are either from the northern region of Nigeria or the western region, who made them what they think they are today. They are submissive and serve their interest, but that is not the topic for today. What we have today is to look at the legal personalities who are, on the other hand, the governors of southeastern states of Nigeria under the leadership of President Ahmed Tinubu. As governors of each state, they have responsibilities under international law. This is because they have responsibilities to protect the interests of the people and as well to account for their services to the people, as well as providing the necessary required securities. Unfortunately, they have turned the security of the states into active war zone. Therefore, they are responsible for whatever that happens to the state, to the people, either through their omission or neglect or inabilities to protect the people, because they have been accumulating the security money which has been donated by various countries to Nigeria by activating the position of insecurity in the country. Therefore, they are accountable to any debt, any appropriation of the finances allocated to them for the security of the people, as well as taking responsibilities under international law. There is no doubt that the government of Muhammadu Buhari and now the government of Ahmed Tinubu declared IPOB as terrorist organization, of which the federal government of Nigeria and the state governors of southeastern region declared war on the IPOB members. But at the same time, they neglect Article 3 of Geneva Convention, which prohibits the following: violence to life and person, in particular murder of all kinds, mutilation, cruel treatment and torture, taking of hostages, outrages upon personal dignity, in particular humiliating and degrading treatment, the passing of sentences and the carrying out of execution without previous judgment pronounced by a regular constituted court, affording all the judicial grantees which are recognized. The wounded and the sick shall be collected and cared for. An impartial humanitarian body, such as International Committee of the Red Cross, may offer its services to the parties to the conflict. Finally, the parties to the conflict should further endeavor to bring into force, by means of special agreements, all or part of other provisions of the present convention. The application of the preceding provisions shall not affect the legal status of the parties to the conflict. Therefore, the high contracting parties, each party to the conflict, shall be bound to apply as a minimum of what has been detailed out. Now, but before we go on, we would like to hear from the international lawyers what they have to say about the personalities under international law. The governors are the personalities, the custodian of Nigerian laws in the various states they govern, and therefore are bound to give account before any legal organization for their activities during these conflicts. Let us hear them and what they have to say. First, we will look at the state responsibility in international law.
Responsibility sets the legal results of a state wrongful act, its obligations and the rights and powers of any state affected by the wrongdoing. Such a responsibility arises when an act or omission of a state constitutes a breach of an international obligation. The conduct is attributable to a state where it is undertaken by its organs, or public servants and entities, or by persons under its control. However, a state cannot escape responsibility where that entity exceeds its authority. On the other side, a state can be responsible for the wrongful acts of another if it provides assistance, or directs and controls the other state, or where it forces another state to commit an wrongful act. Unless it violates a jus cogens norm, the wrongfulness of an act of a state is excused in the following cases. The victim states approved the conduct. The act is a countermeasure or a self-defense, or caused by force majeure, or carried out in distress, or to safeguard the state's interest without affecting others. In all cases, the legal consequences of a wrongful act include the following duties on the wrongdoer state: to perform the obligation breached, to cease and not repeat the wrongful act, and to pay reparation, while taking into account the victim state contributory negligence. Lastly, a serious breach of international law invokes the interest of all states to end it, and the victim state can as well take lawful countermeasures based on proportionality.
Distinction. And this is because one can have a broad or a narrow understanding of what it means to have a legal personality. Under the broad definition, having legal personality means having rights and or obligations under the relevant legal order. And in that sense, one could say that individuals are now subjects of international law because they are conferred rights and also obligations under international law. International human rights protect individuals, while each of us is bound under international law not to commit certain grave crimes like genocide or war crimes. In that sense, we as individuals, we are subjects of international law. However, our legal personality is only passive. We do not create by ourselves those rights and obligations that are bestowed upon us by international legal instruments. We do not master those instruments. Those instruments are mastered by other subjects, and most notably by states and international organizations. And because of this, those latter subjects can be said to have an active personality under international law. And this is the narrow definition of legal personality. Having rights and or obligations under international law is not sufficient. What matters is having the legal capacity to participate in the creation of new rights and new obligations, at least for oneself, and to do that through legal instruments that are instruments of international law. The distinction between active and passive legal personality is not much different from the distinction between being a subject of regulation and an object of regulation, between regulating and being regulated. Of course, the distinction is dogmatic, and sometimes things are a bit blurred. And for instance, it is difficult to decide if the capacity to vindicate bestowed rights is an element of active or passive personality. And let me illustrate this. Today, individuals and corporations are not only conferred rights under human rights treaties or under investment treaties, but they are increasingly given access to redress mechanisms, including sometimes courts and tribunals that allow them to vindicate those rights at the international level against the public authorities that failed to respect those protected rights. Well, does that make individuals or corporations active subjects of international law?
That's a question we have to answer ourselves. However, it is the responsibility of a state to engage if the actions of its agents or actions otherwise attributable to it internationally wrong acts in violation of its international obligations. That is what it means. For instance, in the case of the state governors in southeastern part of Nigeria, in the process of pursuing the members of indigenous people of Biafra or any group of individuals that they considered carrying out activities prohibited by law. There is no doubt that domestically the governors believe they are not touchable. Neither can anyone take legal action against their activities. It is better they understand that what they represent is the state under international law. It is better to inform the governors also that any disproportionate attacks against the armless youth of southeastern region are expressly prohibited by international humanitarian law. These disproportionate attacks amounts or is considered a war crime by the Roman Statute of International Criminal Court. This is because these attacks are committed intentionally to inflict injuries or show the victims that they don't have the ability or credibility to respond to such attacks. Again, it is the objective of mass media to inform the public and the governors also that the activities they pursue are being monitored under international law because they have obligations to fulfill. They have to respect the rights of the people and know that there may be consequences. With today's, we come to the end of this very program. We ask you to subscribe to this channel, like, share, and leave your comment. Until we come to you once again with another edition. Thank you for watching, and may God bless you all. Bye.